Welcome, welcome, welcome. You are joining Let's Talk Immigration, episode 16, I think. And today we have some news in the immigration field. The Biden administration this week has proposed a new rule that I believe is going in the Federal Register tomorrow to give the public 30 days to comment on it. And the new rule concerns people that are seeking asylum in the United States, particularly at the border, at the southwest border. What the rule says that there will be a presumption that the asylum seeker should have sought asylum at one of the countries on the way. So if you're coming from Russia or Haiti, or for example, and you go to Mexico and then you seek asylum at the U.S. border, the U.S. is going to say, well, why didn't you seek asylum in Mexico? And it's going to be used against you for purposes of asylum. Of course, the only country this doesn't apply to is Mexico. If you're seeking asylum from Mexico, which in rare cases that does happen, this rule doesn't apply to you really because you didn't go through another country to get to the U.S. So it's a Trump era rule. Under the Trump era, he tried to do this and it was called a transit ban and had to cancel it, or the court canceled it. I can't remember. Biden has tweaked it to where it might fly. I don't know. I'm really upset because the presumption is behind this is, hey, don't come this way, come the legal way. And at the same time, a lot of my clients know this. Secretary Blinken with the State Department is putting up unreasonable and unlawful barriers to migrants and immigrants seeking to immigrate to the U.S. Two big examples, the diversity visa appeals. And second one is the way the administration is prioritizing students and visitors over immigrants, such that many immigration categories, like spouses of green card holders at certain embassies like Islamabad or India, will now have to wait up to years to be together. And they've already waited years, right? So I think that if the administration wants to take hey, let's limit this way of coming because you have that other way, well, then they're going to have to make that other way work. And right now, it seems as if the Biden administration is taking the restrictive approach that the Trump administration took, that they don't want anybody to come. And it makes me angry because immigrants enrich our country culturally and economically. They add value. Every time a migrant or an immigrant comes into the United States, they add to the wealth of our nation. And I think that this presumption that the Biden administration has basically stolen from the Trump administration that says, oh, immigrants are bad, is stupid. And I don't understand why we will even allow him to be the nominee for re-election in 2024 as a Democrat, because he doesn't stand for what the Democratic Party stands for right now. It just makes me angry that everybody's giving him a pass. He needs to be called out for that. So, and that's not the only thing he needs to be called out for, but because I'm working here in this little immigration space, that's what I'm upset about. Okay, so we have some other news. I'll share my screen. Can I? Yes. I have the technology. I can do this. Okay. This is a letter that the Biden administration filed today. When I say the Biden administration, I mean their attorneys. Attorney Kara Osterberg, who is a trial attorney, it looks like, with OIL, Office of Immigration Litigation. Oh, she's senior litigation counsel. Sorry. she has filed this letter with the court in the DV cases. That includes Goodluck, but all these other appeals include like Gomez and Ray and, Mohammed Fong, John Kennedy, Aker, Gold, every DV case that was appealed by the Biden administration. She's filed this letter, and in this letter, they say defendants want to notify the Circuit Court of Appeals, that's who's considering the appeal, of this recent decision in Arello versus McDonnell, which provides guidance related to the question in the appeal. What they write is, in Arello, the Supreme Court decided whether a statute, I'm skipping the numbers, which governs the effective date of an award of disability compensation to a U.S. military veterans was subject to equitable tolling. Equitable tolling is another way to say whether the court can give relief at a later time, even though Congress didn't provide for that explicitly. And so that's how they think that this case is analogous. Although the government awarded the veteran benefits after receiving his application, the veteran further sought 30 years of retroactive payments. And I just read part of the case, and that's true. The veteran left the service in 1981, but did not find out that his medical condition was as a result of the trauma from his service until 2010. So I guess that is 30 years. The veteran argued that the government should have equitably told the statutory timeline to make his award effective as of the date of his discharge, which his illness prevented him from applying for benefits sooner. Basically, he had mental illness from the time he got out, so he never applied for his disability. And by the time he applied for it, he's saying he should have got back disability. And he should have. But that's not what the Supreme Court found. Unanimously, the Supreme Court held that the equitable tolling was unavailable because it conflicted with the relevant statute's text and structure. The court recognized the hard and fast limits on retroactive benefits that can create harsh results. Okay, we're not looking for a retroactive benefit. That's not what's going on here. Congress could have designed a scheme that allowed adjudicators to maximize fairness in every case, but Congress has the power to choose between rules and standards. It's really ironic to hear the Biden administration talking about rules and standards when the way we got here is they didn't follow the rules and standards of the Immigration and Nationality Act. Okay, I'm sorry, I'm not doing a good job because I keep getting in these tangents. The court concluded that an equitable extension of the 1-year grace period would disrupt that choice. Here, when they say here, they're talking about the Goodluck Gomez cases. Equitable relief is similarly unavailable in the context of statutory fiscal year deadline for the diversity visa program. Under the Immigration and Nationality Act, DV selectees shall remain eligible to receive such visas only through the end of the specific fiscal year for which they were selected, and they point to the diversity visa statute. The funny thing is they're acting like this is some sort of holy grail, some sort of like the Bible or Quran where you have to, oh my gosh, it's 8 USC 1154. Well, 8 USC 1154 also says that the statutory cap of annual diversity visas they can issue every year is 55,000. And in 2022, they issued 55,800. So where'd those 800 visas come from? Just as the Supreme Court held in Arello, equitable relief, sorry, I'm not saying that right, is unavailable here where it contradicts the DV program's statutory limits. And like I just said, statutory limits, all of a sudden they care about that. Didn't care about last year, but now it's important. Moreover, Congress has passed legislative responses to address certain impediments facing DV applicants reinforce this conclusion. They're talking about that one time where Congress allowed DVs in a conflict zone in Africa to make application to attend interviews after September 30th. Congress did that one time, a long time ago, when Congress was a more functioning body, which is not the case now. So that concludes the supplement that the government attorneys filed with the court today, with the clerk of the U.S. Court of Appeals. I want to say something very important here. This is just them blah, 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 blah. It's not the court's decision. The court makes the decision. The Circuit Court of Appeals for the District of Columbia is who will issue the appeal on these issues that are before that court in the appeal. This is just what the government says. There are going to be some people in some Telegram groups that are going to say, oh, we lost. That's not what this is, okay? So beware people that are coming to conclusions without studying what's happening, because that's not what's happening here. This is just the government making a desperate argument. And I wanted to explain to you what the argument's about so that you would understand it. So I'm going to do a little bit more explaining. How about that? This is the opinion that Ms. Osterberg has brought to the Circuit Court of Appeals' attention. And it was a Supreme Court decision that just came out. It was argued in October, and it was decided today. It was decided in January 23rd. Okay. Concerns the effective date of an award of a disability compensation to a veteran of the United States military. It's ironic that the Biden administration isn't only fighting diversity visa selectees, but they're also fighting veterans, people that serve in our military. So here's what this case held, according to the Supreme Court in their one paragraph here. Section 5110B1 is not subject to equitable tolling. Notice, that's 51TB1. That's not the 1154 DV statute, right? That's a different statute. Equitable tolling effectively extends an otherwise discrete limitations period set by Congress when a litigant diligently pursues his rights, but extraordinary circumstances prevent him from bringing a timely action. Y'all brought a timely action. You filed your lawsuit. DV 2020 selectees, we filed our lawsuits in 2020. DV 2021 good luck and Ray plaintiffs and go plaintiffs, you Jacob plaintiffs, you filed your lawsuits in 2021. So you did timely bring your action. Okay. So there's no extraordinary circumstances preventing you from bringing a timely action. Basically, the government is wrong, okay? Very, very desperate that they tried to say the DV case is like this case. So that's what I have to say about that. Okay. What else is going on? Our ICE lawsuit, Asylum Seekers versus Johnson. Actually, it's Asylum Seekers trying to assure their safety versus Johnson. But I'm going to start saying it's Asylum Seekers versus Johnson. On Friday, we filed amended complaint. And in that amended complaint, we've added several more plaintiffs. We are not adding any more, but now there are 49 plaintiffs from many countries, more than 10. And also I have co-counsel now, 6 attorneys from 5 different firms, I think, or 7 attorneys from 6 different firms, I forget, have joined me in that case. So we are stronger. And now I'm working on the motion for class certification in that case, which hopefully will be filing in the next couple weeks. Okay. Moving on to Naveed versus Blinken on Saturday. No? Yes. Saturday, I filed our opposition to the government's motion to dismiss with exhibits. And the government's reply to that opposition is this Friday. I was excited to file that because I found something in the FAM code I didn't know existed. Basically, there's a section of the FAM code with the heading timeliness of interview that says that 30, 60-day thing that Congress said that, State departments should strive to adjudicate applications within 30 days for these immediate relative categories, 60 days for all other categories. The heading in the FAM code for that is timeliness of interview. It's not timeliness of visa adjudication, because at our last hearing, some of you will remember who listened, the AUSA Michelle Ramos, representing the Biden administration, argued that, bad faith argument, that 30 or 60 days applied to after the interview. And even the State Department knew that was a lie when she made that argument. So I enjoyed pointing that out in our opposition brief, and I'm looking forward to Ms. Ramos's reply brief this Saturday to see how she addresses that situation. Also, a lot of people ask about the progress of that. There's only 10, but that case, Naveed, involves some very important issues, but only involves 10 plaintiffs, beneficiary plaintiffs, visa applicants. And so far, 2 have been set for interview, and we're waiting for interviews for the 8. So little progress, but not what we want. We want we always want all of our plaintiffs to get visas. That's always what we want first. And if we can get some policy changes that make it better for everybody along the way, that's great too. So that's an update on Naveed. I'm probably supposed to have other updates, but I can't think of what they are. So I'm going to jump straight into questions. Firishan is trying to be patient for DV 2021. Is it possible for the appeal court to ignore our case? Good luck and not make a decision. No, that's not possible. Just because they don't have a deadline does not mean that they will not issue an opinion. Okay, that's never happened before. They will issue an opinion when it's ready. Omar says, welcome, Curtis. Nice to see you. Well, I can't see you, Omar, but thank you. Can you give us some motivation? Every year, monarch butterflies will like hibernate and fly from one continent to another, and they're beautiful, and they have to they start out as, what is butterflies? I wish somebody was here with me. Butterflies start out as not snails, little worms or something. I don't know. They come out of their cocoons. Someone's popping in to help me. Isabella, what are butterflies? Where they come from?
Caterpillars. Cocoons and caterpillars.
Thank you for saving me. Okay. So I needed that. So caterpillars turn into butterflies. So they evolve. And they do this beautiful thing, and it involves like mass migration from like parts of Mexico and Central America all the way up to Canada. If little butterflies can do that, you can do that too, DVs. Hang in there. We started out back in 2020 and 2021 as little caterpillars, but someday you're going to be butterflies, okay? That's the best I can do for motivation. And thank you, Isabella, for helping. Modasim says hello. Hello. Omar says, why our case have 3 judges? I see other cases in the appeal court have 1 judge, but we have 3. Why? I don't see other cases in the Circuit Court of Appeals that have 1 judge. I think maybe you're seeing cases at other appeals courts, or like maybe state appeal courts. I don't know. I don't know what you're looking at. Appeals, like when you go before a district court, you have 1 judge. When you appeal that district court judge's order and you go for a Circuit Court of Appeals, you have 3 judges. That's the way I understand it works. So if you have an example that's different, Omar, message me or email me that, and I want to look at it. Hi, Lamine. Lakar says, we get old. Do you think my hair was this color when I started before immigration? Okay. Hello, Utaba. Okay. Valbona is talking about F3 and F4 categories. I wrote a blog entry. I don't know if any of you all like go to our website and look at our blogs, but if ever you do, if you're bored and you can't sleep and you want to read things that I ramble about on our blog, this is our blog, right? No, this is our website. More blog. I wrote a blog, published it this morning, about context for Biden's transit ban, and I made 2 points. One point was that of course, for the DVs, the Biden administration is fighting. Instead of just issuing those 20,000 reserved visas, they're fighting us. And the second one is Secretary Blinken's NIV prioritization scheme. Oh my gosh, you all can't see that because it's too small. This is something that we are challenging in our lawsuit, Sonny, Santos, and Wilson, before Judge Kogan in the Eastern District of New York, and also in our Naveed lawsuit in the District Court of Columbia. This is where the Secretary Blinken and the Biden administration had decided that tourist and student visas are more important. And as a result, lots of things have happened. Last year, 57,000 family preference category visas went unused. Okay, so they just like rolled over to employment visas for this year. Also, it's since family preference visas are not being issued, the visa bulletin barely moved for the last 18 months. Okay. Also, from November 30th to January 31st, that's 2 months. The immigrant visa backlog increased over 8%. It's going up. It's not going down. They're throttling immigration. They're keeping immigrants out. Okay. I'm not going to go there. The third thing I want to say is that statistically, this is interesting. Back in October of 2021, the immigrant visas made up 11% of the total number of visas issued. They issued 332,000, 36,000 were immigrant visas. As of December, it's 6%. Basically, the percentage of immigrant visas of the total number of visas has gone down dramatically, not quite 50%, but maybe 40% since Secretary Blinken started his NIV prioritization scheme. So anyway, I just wanted to rant about that since you said F3 and F4, because the NIV prioritization scheme is causing the most harm to categories F1, F2B, who's aren't current, also to F2A though, F3 and F4. F3 and F4 is causing so much damage because there are so many people that thought that their cases would be current in the visa bulletin, and they're not, and it's for 18 months. And then there are people that are waiting that thought they had 5 more years, and it looks like maybe they got 10 more years. Who knows? Because the bulletin's not moving. So I feel you on F3, F4. That's what I'm getting at. Andre says hello. Hello, Andre. You thank me for my effort to provide for immigration. My question, what is the DV 2020 situation? We can still have hope for. The situation is you can still have hope. I will let you know when you should not have hope. But if you were not issued a visa in 2020 and you were a DV 2020 selectee, you are a Gomez class member and you need to wait to find out what happens. Abdul Qadir Jatia. You're trying to use my channel to promote your channel. I don't even know what your channel is about. You got to tell me what your online business is if you want me to help you promote. What about F2B, no movement? as I was just going into a rant about that. That's true. No movement in the visa bulletin or no movement at most embassies. I agree it's a problem. If you are already DQ and your family has the resources, I would recommend a mandamus lawsuit. F2B is unmarried child of a green card holder, for those of you wondering. Okay. Sila says, if we win good luck appeal, I need to have a guest that just reads the question so I don't have to. If we win the good luck appeal and one is scheduled in a non-performing embassy, okay, stop there. That isn't going to happen. I think what you mean is you're assigned to a non-performing embassy. Is it possible for the court order to compel the embassies to adjudicate these good luck cases? Some embassies are doing so bad. Well, the question of whether or not it is possible is not relevant because it will not happen. There are only two judges, district court judges overseeing the orders. There's only two judges that reserved visas for DB 2020 and 2021, Judge Mehta and Judge I'm going to call me Judge Shutkin. Okay. And both of those judges take the viewpoint that they do not micromanage in embassy affairs, which is what most judges do. Most judges will not get involved and tell a specific embassy, oh, you need to be open when you're not. So is it possible? Maybe, but it's not going to happen. So if your case is assigned at an embassy that's closed, take Moscow as an example, I recommend that you get out of that area and get into a country where the U.S. embassy is not closed, because at least then you might have the opportunity to transfer your case, where you do not have that opportunity if you're stuck in a country where the embassy is closed. I think you're talking about embassies that are just doing bad, like Addis Ababa. And same thing kind of applies. If there's any way you can get out of Ethiopia and get into another country that does not have, where the embassy is performing well, it's a good idea. I realize that's almost impossible for most people, but throw it out there as an option. Ines says, Mr. Oppenheimer believes we can expect some family-sponsored final procedure dates to begin moving forward at some point over the coming months. He believes the final Mexico F2A date will be imposed, possibly as early May. That means retrogression for you all wanting. What does that mean, a final action date? It means that F2As that are waiting for interviews now, some of them will be told by the visa bulletin, no, you're not eligible anymore, not for 6 months or a year or 2 years or something like that. So I think that that's possible with F2As, not because of what happens at Islamabad, but what's happening at other embassies that are really going crazy issuing visas, like Santo Domingo in the Dominican Republic, embassies like that. They are, it's weird. There's a disparity. There's some embassies that are doing really good right now, and then there are others that are not. But I want to remind you that Mr. Oppenheimer is not with the U.S. government anymore. So what he believes may not actually, they may be making decisions based on things he doesn't even know. You know, he's gone. He's working private practice now. So Landscapers Jordan says, appreciate your support. Thank you. Hi, Sahir. Kaminari says, if a winner of a DV lottery has a kid under 21 since the day of the DV application, end of fiscal year 2, but by the time the court gives a positive order, the kid is over 21, is the kid disqualified? Well, Kaminari, there is something called CISPA. CSPA, and it will protect a child's age and freeze it in certain situations. If the kid's like 21 now, they're probably okay. If the kid is 22 now, I'm starting to worry. How that calculation works with a reserved visa is some uncertainty because courts have never reserved visas before. The first time they did it was for us in 2020, and this wrong. Judge Chutkan did it in 2017. That was the first time, although those visas still have not been issued. And then the second time was DV 2020, September 30th of 2020 in the Gomez order. And then the third time was Judge Chutkan in her Ray order in September 2021. And the fourth time was Judge Mehta in his Good Luck and Go order. So it's interesting. It was Chutkan, Mehta, Chutkan, Mehta. Those are the four orders that have reserved visas. And none of those visas have been issued yet. So we don't know how CISPA will work with reserved visas. Also, CISPA is a chance for me to vent about the State Department again. Over the last week, USCIS has passed a new rule that says CISPA will be tied to Chart A instead of Chart B. That is fabulous. That means less kids will age out, basically. They grab some months there, or some years, depending on what happens with the visa bulletin. So fabulous. The State Department hasn't adopted that interpretation yet. We're still waiting for the State Department to say something. In fact, I saw an email today. No, I saw a tweet from a colleague where the State Department has denied a visa applicant that would not have been denied, will not deny. They have chosen to take the interpretation that they've always taken and said, oh, this person is aged out, where if they applied the USCIS interpretation, they would not have said that. So it appears that the State Department wants to hang on to every tool that they can to restrict immigration because Secretary Blinken opposes immigration. I don't know why. And I don't know why other Democrats, immigration attorneys are not willing to say that out loud. I don't know if y'all noticed this, but I'm the only person that's saying, fire Blinken, fire Blinken. And I realize there's other stuff he's doing right. I'm just like really sensitive about him throttling immigration when Biden ran on a campaign to replace Trump because of his restrictive immigration policies. So in my view, this is just not an issue that Blinken should have the privilege of ignoring and getting wrong. So got way far away from your question. Is the kid disqualified? Also, you didn't say if it was a reserved year into fiscal year 2. Yes, you're talking about DV 2021. We don't know yet because we don't know how it applied to DV 20 and 2021. There's a CISPA calculator for the way it traditionally applies for family-based immigrants, but it doesn't work really for DVs. Okay, so here maybe I came in a little late, but would you please explain to the audience the latest email you sent them, please? Yep, you came in late. Rewind. I'll do it, and you'll see. Basically, what he's talking about is I sent to our DV 2020 and 2021 clients a link to a letter that the government filed today with the Circuit Court of Appeals saying, hey, our case is just like this other case the Supreme Court just decided, except it's not. And I explained that in detail right before you came. So here. Caminari does a great recap. That's true. It's a far-fetched, desperate attempt by the government. Moment. Hello, Mr. Morrison. I'm a plaintiff in Good Luck. What is the situation if I get married? Do I need to modify my DS if we won the appeal? So, first of all, you cannot modify your DS now because you're good. He's talking about DS 260. Since you're a good luck plaintiff, your visa application is frozen. Okay, it's been deployed to the embassy, but the embassy can't even see it. It's frozen. There's nothing you can do now. So if we beat the appeal, we have to wait on summary judgment. If we win summary judgment, and finally the State Department starts adjudicating DV 2021 good luck plaintiffs and also Ray plaintiffs, in Ray cases, I guess, you would want to email the embassy and say, hey, I need to open my DS-260 and make a change because your family situation on your DS-260 now, the one that you're going to swear an oath to at your interview, currently says that you're single. But if you're married, you only want to change that and say you're married. Now, there's usually a follow-up question. Will I be able to bring my spouse on my DV application? And for DV 2020 and 2021, I don't think so. I don't think that's the way it's going to work because DV 2020, they weren't class members. DV 2021, they were not plaintiffs. But State Department may take an expansive approach and decide to use some visas they just have laying around like they did for the extra DV 2022 visas so that they don't leave new spouses and babies back in the old country. We'll see. But I don't think that I don't think that they'll do that because it's the right thing and they don't normally do the right thing. So let's say that they don't and you're just issued a visa, but your new spouse is not issued a visa. Then you come to the US and you petition for your new spouse, and then that process will take between 2 and 5 years because of backlogs. So you do have a path. It's not a pretty path. It takes a long time, but you do have a path to get your new spouse or child into the US. If it's a new spouse, there's a little trick thing you can do here, okay? Your new spouse can go ahead and apply for a student visa and come to the US and study. It'll be very expensive. US colleges are not cheap. So you have to have the means to be able to do that. But if your US spouse is in the US studying when you happen to come here on an immigrant visa, then we have options, okay? But you can't fake that. Your spouse has to actually go to college and you actually have to write checks and pay for that college and just learn something, you know? So immigration's never easy, man. That's all I gotta say. Okay. Hassan says, if we lose DV 2020-21, but 2-1, let's say supports us. He's talking about a split decision from the appeals court. It will be better looking for a call-all panel because of Washington, D.C. appeal court have more liberal judges than in the Supreme Court. In the Supreme Court, more conservative judges. Or will it be better to bypass all the panel in the appeal court and go to the Supreme Court? I will not be the only decision maker in that, okay? And I think it also is going to involve the legal issue that we win or lose by. So I don't want to really opine on that. I think it depends on the legal issue, and also my colleagues are going to have a lot of will want to weigh in on that. Yeah. It's a very thoughtful question, though. Anne says, good night. She has a little flag there from a country I'm not sure. I should know. When is 2024 DV lottery results? I think that's the first week of May. March. So 2.5 months, 3 months from now. I hope you win. Saleh says clarification and non-performing embassies like yeah, I realized that that's what you meant after I started to answer the question. And so if you have the means to relocate physically, especially with permanent residence outside of Ethiopia, I do recommend that because there are 2 embassies in Africa that were so disappointing last year. There were more than 2, but Addis Ababa in Ethiopia and Khartoum and Sudan were particularly disappointing. And so if you could relocate to another country, that would be wonderful. It's difficult when you say which country. That's difficult. There are embassies I really like in Africa. I like Djibouti and I like Casablanca. However, Casablanca they have a lot of DVs already because there's a lot of Moroccan DVs. So you'd have to compete with them. But that embassy really knows how to do volume. Okay. Marieska says, please, DV 2020. Talked about that earlier. Have to wait for the outcome of the appeal. And it says, according to your long experience in the legal profession, I'm old, but I haven't had a long experience in the legal profession, by the way. This is my second career, or third. It's my third career. Contacts and acquaintances in the courts. I don't have too many friends in the courts. They went to very expensive colleges on the East Coast. What is the maximum period for issuing the decision? Oh, that's what you're trying to get at. There's not a maximum period for issuing the decision, Anna. So no matter how many qualifications you put on the question, anybody that answers that question is committing malpractice because there's not a maximum period for issuing a decision. Judges have discretion over their dockets. The decisions do not exceed 6 months, or can we wait for years? You could wait for years. Very unlikely that it's going to be years, but judges have discretion over their dockets. You said, I am one of the Gomez plaintiffs. No, you're not. There were only 7 or 8 Gomez plaintiffs that were DVs, and they were all issued visas in September of 2020. So you are one of the Gomez class members. I'm not sure if you're a plaintiff, but you're a Gomez class member, not a Gomez plaintiff. Okay. Graciela says, good afternoon, please. Could you do the next live chat in Spanish? Mi español muy triste. I will see if I can find a translator to do a live in Spanish. Gladys and our team, I'll check her availability. Thank you for the request, Graciela. Gracias. DV 2021. Well, Yusuf, if you were not a good luck plaintiff and you do not benefit from the Ray order, your DV 2021 journey is over. That's my answer for DV 2021. If you're a good luck plaintiff or you could benefit from the Ray order, that's a different question. So it's been a good 45 minutes. I appreciate all my loyal listeners who showed up. I get the takeaway that you need us to have some lives in some other languages, so I will try to line that up. I don't think that they will be full 1-hour sessions, maybe 30-minute sessions, because a lot of the information I repeat over and over and over every time the question's asked, and we don't need to do that. Okay. If once a question is asked and answered, it's there. Okay. So, Yusuf says he's in good luck. Well, Yusuf, as you received an email today from me, you should have, we have to wait on the appeal, right? Like that's the news and good luck. Yes, the government filed a letter, but we still have to wait on the opinion from the appeal court. Nothing moves forward in good luck until the circuit court for the District of Columbia, Circuit Court of Appeals for the District Court of Columbia, for the District of something like that, until they issue the opinion. That's what we're waiting on. So anyway, thank you, everybody. Have a great week.